Good morning. Welcome to Coffee with CartLaw Alabama. My name is Darrell Cartwright. I'm an attorney in Birmingham, practicing throughout the state of Alabama. This morning, I wanted to talk to you about a case I saw recently in the news, in the headlines. And you may have seen this also. A newspaper story was about a company in Kentucky that got sued, and a jury verdict was awarded to the employee for $450,000 because the company gave the employee a birthday party. Well, that's a sensationalistic type of headline. And as some things sometimes occur in the media, not exactly the entire story. So what I want to do today was talk about the rest of the story. In this case in Kentucky, the employee of a company called Gravity Diagnostics, told his supervisor that he suffered from anxiety and he did not want to have a birthday party at work. He warned his supervisor that, hey, if I have that, it may bring up distressing memories of my parents' divorce. Well, apparently the supervisor forgot to tell other people, and they held a surprise birthday party for the employee at work. The employee suffered a panic attack over it, went to his car to finish his lunch. Now, at this point, the company probably isn't legally liable for anything. So the headlines that they got sued for giving him a birthday party, completely misleading. If it had stopped here, the odds are we never would have heard about this individual and this company, but it didn't stop there. Here's what happened next. The next day, the company called the employee in for a meeting. And at that point, they berated the employee, read him the riot act, criticizing him for taking the joy, stealing the joy of other coworkers because of the way he reacted at the party. At that point, he began utilizing some coping techniques that he had learned in therapy. And apparently there was something like you clench your fists and cross your arms against your chest. I'm not sure exactly what that is, but he began using it. They told him to stop. And then they sent him home, told him, do not come back for a few days. Before his return, they emailed him and fired him by email. Now, what occurred after the party is the reason the company was sued and the reason the company was found liable. There's a federal law called the Americans with Disabilities Act. And basically, the very simplistic version is that a company is required to provide a reasonable accommodation for an employee with a known disability. Now, would a reasonable accommodation in this situation have been to allow the employee to not be criticized for eating his lunch in the car after the panic attack? Well, certainly it would. Would a reasonable accommodation have been to allow him to use the coping techniques that he learned in therapy? Certainly. That's what the jury said, at least. And maybe not to berate him at all and to read him the riot act about that. Would that have been a reasonable accommodation? The jury certainly thought so as well. And then finally, of course, the big one, would a reasonable accommodation have been not to terminate him at all for those same actions? And the jury again found that that was a violation of the Americans with Disabilities Act not to do so. 40 million adults suffer from anxiety disorders, which is the most common mental illness in America, according to the Anxiety and Depression Association of America. The company's failure to recognize that disability and to accommodate for it once the disability occurred gave rise to a jury verdict of $300,000 for emotional distress and $150,000 for lost wages. Now, I understand the case is on appeal, and the defendant company has made the argument that they were not notified of the disability by the employee. If that's the case, then arguably no liability should have occurred. Generally, a company is liable only when they fail to accommodate a known disability. So there's a reasonable chance, if the company is successful, that the verdict may be overturned. And my point today in spending a few minutes with you was not to discuss the merits of the case, but really to discuss what happened beyond the headline of the newspaper story and how companies and clients that I have may avoid making the same mistakes that this particular company did. What they did was wrong, perhaps bad judgment in giving the employee the birthday party, the surprise birthday party that he did not want. But that wasn't why they were held liable. What they were held liable for was everything that occurred afterward, the way they handled it in criticizing and berating the employee, not allowing him to use his coping techniques, sending him home, not allowing him to work, and then finally terminating him because of that disability. Those are the kind of things that all employers should be cognizant of when dealing with an employee with a disability. Thanks for spending a few minutes with me this morning. I look forward to spending a few minutes with you next time on Coffee with CartLaw Alabama. Have a great day.